Let's look at it from the beginning. Justice Binta Nyako of the Federal High Court in Abuja has struck out 8 of the 15 counts filed against the proscribed IPOB leader Nnamdi Kanu, that they were incompetent for not disclosing any valid offenses against the defendants. How do you react to these judgments, BKO?
I think I agree absolutely with the trial judge, because many times the prosecution just tries to show that it has a very valid case against an accused person. They will now come up with multiple charges and all that, when all of those charges put together can be consolidated into a single charge. So what is the point in having a 50-count charge, for example, as we've seen in the past? What is the point in having a 50-count charge when you can actually have a 5-count charge or a 2-count charge that is very valid, that can lead you to a kind of prima facie case against an accused person? So what the judge said was that there were so many that the charges were mere repetitions, that did not disclose any offense that could be sustained by proof of evidence. So the judge was right, and what the judge has simply done is to say, okay, I okayed the trial based on count 1, count 2, count 3, count 4, count 5, count 8, and count 15. So which means that the rest of those things that Kanu was accused of doing in the remaining counts did not matter, because they amounted to repetitions that did not disclose the real offense that was committed. Of course, Kanu was accused of broadcasting or issuing deadly threats against Nigerians through his broadcasts, and that in one of those broadcasts, he warned that anyone that flouted his sit-at-home directive should write his will. He was also accused on diverse days, that's between 2018 and 2021, of making a broadcast inciting members of the public to hunt and kill Nigerian security officials and their family members, contrary to Section 1, subsection 2H of the Terrorism Prevention Act of the year 2013. Now, in count 8, one of the charges that the judge allowed the prosecution to sustain, in count 8, it was alleged that Kanu directed members of IPOB to manufacture bombs. In count 15, which was also allowed by the judge as one of the basis to try the defendant, it was said that between March and April 2015, he imported into Nigeria and kept it within the jurisdiction of the court a radio transmitter known as Tram 50L, containing a container of used items, which was declared as used household items, contrary to Section 47, subsection 2 of the Criminal Code. So you will see in the various counts that the judge permitted to be sustained, you see clear charges leveled against him. You see offenses stated. But in a situation in which some of those charges did not disclose the offense committed, the judge had no choice but to remove them and prune everything down, prune the charges down. It is not until you bring 50-count charge 40 count charge, 1 million count charge before you can sustain a case against an accused person. We've had this so many times, happening so many times, involving the EFCC. The EFCC will bring an accused person to court, accused of stealing our money, and they will be talking about a 50 count charge. Whereas at the end of the day, this 50 count charge can effectively be pruned down to just 10 or even 5. And by the time they get to court, you see that they will not be able to sustain their case against such individuals based on the multiple charges that they are brought up, that they really cannot sustain. So I think the judge was fair enough. The judge was right to have taken that decision. Now we are going fully into the trial. You know, this whole thing, the judge had to rule on Kanu's application that his detention and trial was illegal, you know, and Kanu's lawyer argued that the trial shouldn't even have been brought up in the first place. So it was in the process trying to be charged, took that the charges against him, and then removed those that the judge felt amounted to repetition and could eventually waste the time of the court. So Kanu was the one who filed the application before the judge to say, look, your court does not even have jurisdiction to try me, because in the view of Kanu's lawyer, Michael Sekome, the offenses that Kanu was said to have committed were committed outside of our country. And as far as the lawyer was concerned, the court did not have jurisdiction. But as we have seen, some of the charges indicated that the offenses were committed right here in Nigeria, like the matter of the weapons that were brought into the country, you know, the transmitter that was brought into the country in the guise of used items. Of course, that one is a matter that can be tried by a Nigerian court, especially the Federal High Court that is handling the matter now. So that's how we came to this point, that the judge had to now look at the entire charges. Right. It was because Kanu demanded that the case against him should be quashed. Right. That the judge now looked at all the charges and then determined in her wisdom that, look, not all of these cases can be sustained. So the ones that, not all of these charges can be sustained. The ones that can be sustained in her view, she has now left those ones and has ordered Kanu's lawyer to defend those allegations. I mean, right. In respect of the charges that have been left.